Good morning. May it please the court. I'm attorney Dana Gravina. I represent William Camuti. The sole issue before the court this morning in this case is whether or not the motion judge erred when he concluded that a reasonably effective attorney would not have sought DNA testing of the shirt worn by Stephen Rakes on
A
the
reasonably effective juror want testing to step on what really was the only defense that they had, that there was no forensic evidence connecting the defendant to the murder. And I'm not going to go through it all, but in the face of the GPS, the confession, the searches on the internet, they got one issue. And you're going to step on that one issue and maybe have forensic evidence that ties the defendant? What reasonable lawyer would do that?
Your Honor, that was not the status of the case, and that was not the status of the defense. The defense did not rely upon the fact that no DNA testing had been done on this shirt. When you look at what the defense...
But maybe. I mean, there was a Bowden element, but that's not really my point. The point is that there's nothing forensically to connect this defendant to this murder in the face of all of that other evidence. Do you take that defense that you have and then take a chance of stepping on it in the face of what else is going on?
But again, that was not the defense. The defense was not, there's no forensic evidence here, and that if you test the shirt, it's going to deprive us of that defense. The defense was that there was, and this was not the main defense. Part of the defense was that there was no biological evidence, meaning there was nothing of Stephen Rakes, no blood, no DNA found in Mr. Camuti's vehicle, in his apartment, in his storage unit, and there were no tire impressions, footwear impressions found at the scene. Those were the things that defense counsel did address. None of that would be affected by having the shirt tested for DNA, regardless of whether the results came back that Mr. Camuti's DNA was on the shirt or not.
But trial counsel took advantage of that. And I know that, again, you're doing the best you can on appeal to give the best case that the best gloss to your case that you can. But on cross-examination, there was absolutely cross-examination done with the state trooper investigation and DNA witness to say that there wasn't any. So the idea that somehow it wasn't a part of this, and again, back to Justice Lowy's point, there's a lot of evidence here against Mr. Rakes. So this one part that you do ask about on cross-examination of the state's DNA expert, that wouldn't be a dumb thing to do as a trial lawyer to do that, to step on that?
Your Honor, there were 5 pages of testimony out of over 1,600 pages of testimony.
Sure, but
in which that was addressed.
How much testimony do you need to say no and none?
And I think, again, there was very little testimony, and then it is not referenced at all in closing argument. Not once does trial counsel in his closing argument say anything about the fact that the shirt was not tested.
You're being a little, so the closing argument, the defense attorney said there was 0 trace evidence, correct?
Correct.
Right, and the evidence on the shirt would have been trace evidence, right?
That's not what he was referring to. He was referring to there's no evidence in the sense of footwear impressions, tire track impressions. That's what he was talking about in terms of trace evidence.
But writ large, there's no physical evidence connecting Mr. Camuti to the crime scene. That was the theme of the defense, or a theme of the defense.
A very minor theme of the defense was that there was no biological evidence found in the car, the apartment, or the storage unit, and there were no tire track impressions, no footwear impressions. But it was not a big part of the defense. And
what was the defense then?
the defense was that there was no motive for Mr. Camuti to have done this because Mr. Rakes was his best friend, was his business partner, and that Mr. Camuti's debts that he owed to various people, that he had the best chance possible of repaying those debts not by killing Mr. Rakes, but by keeping Mr. Rakes alive, because those business deals he had with Mr. Rakes were the way that he could possibly get out of debt. Had those business deals, been productive and gone forward. In addition, part of the defense was that there was no way that Mr. Camuti, who is an older gentleman, very small, much, much smaller than Mr. Rakes, could have pulled him out of the car and dragged him into the woods, that was simply impossible. Another part of the
And
defense.
so that part of the defense wouldn't potentially be jeopardized by the DNA testing?
Absolutely not. Mr. Camuti admitted that Mr. Rakes and he met that day when Mr. Rakes died, that they had a meeting, that Mr. Rakes was in his car. So he had a completely innocent explanation for why his DNA may have been on the shirt.
So best case scenario, what would you hope that the DNA evidence would show?
That there was another individual's shirt, another individual's DNA on the shirt. And that would have provided a third-party culprit defense to Mr. Camuti. And there's reason to think that there would have been another person's DNA on the shirt. Again, one of the things that was put forward was this was.
Can you explain that last statement? Why was there reason to believe that a third-party culprit's DNA would be on there?
Because Mr. Camuti, and the jury had an opportunity to view this, and counsel did point it out, was an older gentleman, very, very small gentleman. Mr. Rakes was a large gentleman. The idea that Mr. Camuti could have dragged Mr. Rakes out of the car after Mr. Rakes was deceased and dragged him into the woods is very hard to believe.
But what point does that make? Justice Wendland's point is what I'm thinking. Well, gee, don't test the shirt. You've got a great argument there, maybe the only argument you have. Why would you step on that argument and test the shirt in the face of the confessions, in the face of the internet searches and the email on the GPS? Why would you? That seems to me, as Justice Wendland was suggesting, a really good reason not to test the shirt.
Your Honor, all the evidence that you're pointing out is the exact reason why you have to test the shirt. No jury was going to come back, or I would say no reasonable attorney would think that a jury is going to come back with a not guilty verdict in light of all of that evidence with your point that you've pointed out by simply arguing to the jury, well, Mr. Camuti's DNA is not on the shirt. They never tested it.
We have to look at the exculpatory value, the potential exculpatory value of the thing that wasn't tested, correct? And here we're dealing with trace evidence. This is unlike a rape where there's, biological material clearly identifying who the perpetrator is. This is trace evidence on a shirt that could be deposited who knows when, right? It could be a waiter that bumps into somebody. It's really, so address the exculpatory value of the, and this is what Winton says, of the trace evidence.
Your Honor, again, had the shirt been tested, we don't know what the results would have been, right? I mean, we know that had the shirt been tested,
Right, but
possibly.
Best case scenario, it comes to someone other than your client.
Correct, and it's run through core links and it comes back to someone who has a history of violent crimes. Maybe someone who knows Stephen Rakes and has motive to kill him. We don't know, that's the problem. This hasn't been done. We don't know what that is going to, what's going to turn up. I mean, Mr. Rakes, the day that he showed up on the side of the woods, deceased, he was, that day, believed that the following day he was going to be called as a witness at the federal trial involving Whitey Bulger. So there's no way to know for sure what was going to be on that shirt when we test it for DNA. But had it been tested and had it come back that there was a third party, that third party had a motive to kill Mr. Rakes, then that certainly would have provided very, very helpful evidence to Mr. Camuti's defense. And again, this is not the standard of would every attorney have done this. This isn't the standard isn't would this attorney that actually tried this case have done this. This is the standard is would a reasonable attorney have
It's Safarian, but lesser than Safarian.
much less. It's would a reasonable, any reasonably effective attorney have done this. And our position is that in light of the
But a
evidence.
reasonably effective lawyer basically torpedo their lack of trace evidence argument?
Again, it would not have torpedoed it because there was an innocent explanation for why the DNA would have been, why Mr. Camuti's DNA would be on the shirt. And there was still all of those other aspects of the defense, which
But
could have
then
been pointed
the
out.
closing would say something like, there's no trace evidence tying my client to the victim other than the DNA. Isn't that a problem?
Not at all.
Oh, and he has the DNA because they met for McDonald's where they had the coffee and where my client, did the cyanide thing.
No, and where he was in my client's car. I mean, Mr. Camuti admitted that he was in the car.
Yeah, but again, you're isolating this, and I think that you're not when Justice Barry Smith is looking at this, you're taking it in isolation, okay? And you're saying there's an innocent explanation for why he was in the car. Yeah, but that innocent explanation is on the heels of two different stories about that meeting. So it's not just, hey, we can explain it because he was in my car. You lied about it twice, about how it went down, okay? So you have that. So you've got a problem with that. So when you're looking at the preponderance of the evidence standard and you're saying, here's all of this stuff that the Commonwealth has, here's all of this stuff that's against us. And again, the Justice Wendland's closing, that's going to be, yeah, I know you've got the differences in the different stories he told about McDonald's, about the cyanide that he's buying, about the GPS, all of that stuff. I get all of that stuff, and nothing else ties except for the shirt now. And you say that's not a problem?
Absolutely not, because there is an innocent explanation for why the DNA is on, why Mr. Camuti's DNA would be on the shirt, if that in fact ended up being the case. We
Can I
don't
ask
know
you
that.
Just a science question, and I don't know the answer to this. My colleagues may, but the DNA testing, would it be by site, location on the shirt? So like armpits, back. And I'm wondering if that's true and your client's DNA was on the back or the armpits, would you still have the, we were at McDonald's together defense?
Absolutely.
Okay, is that how it works, that the DNA will just distribute throughout the shirt if you meet somebody for coffee?
No, but if they're in your car,
Yeah.
I mean, presumably Mr. Camuti's DNA is in his vehicle. There's no reason to think that the DNA wouldn't be transferred from the seat.
The armpits? To the armpits?
Well, when you're sitting in a chair and your back is touching, I mean, there's no reason to think that Mr. Rakes's armpit area, just in the back, would not be touching the car. We don't know. Did they hug when they met at the restaurant for coffee? Did Mr. Camuti at some point put his arm on Mr. Rakes as they were meeting for coffee? We don't know that, but
Detail the level of explanation that you have to give. Doesn't that call into question the reasonableness of doing the testing to begin with?
absolutely not. And again, the standard is whether a reasonable attorney, not everyone, but a reasonable attorney. And I think it is entirely appropriate to say, as a reasonably effective attorney, I am not giving my client a real defense by just pointing out that a shirt wasn't tested for DNA. But I am giving my client a realistic defense if I have that shirt tested and someone else's DNA is on that shirt and they have a motive to kill Stephen Rakes. In light of all of the evidence that's pointing at Mr. Camuti, that would be absolutely a reasonable decision. And an attorney, a reasonably effective attorney, would take that risk of, I'm going to have to explain the DNA on this shirt if it comes back that his DNA is there, in order to get that realistic defense of someone else's DNA is on this shirt and they have a motive to have done this. That's our position.
I don't know, I think when you say that, you're thinking in terms of, well, what's the jury going to think is more likely? And that's not the standard. Commonwealth has to prove the case to a moral certainty, and you stand up in closing argument when they have to prove the case to a moral certainty and go through all the different ways that there's just no trace evidence, there's nothing. I mean, that's a reasonable doubt argument that you have.
Again, I would say that is an exceptionally weak argument in this case. That is not, I wouldn't try the case on that argument. I will say that. I think that is a losing defense. And a reasonably effective attorney could see it that way and say, to give my client a realistic defense, I need to have this shirt tested for DNA. The fact that this attorney didn't do that is not the standard. That's not what we're focused on. We're focused on, could a reasonably effective attorney have seen it this way and said, I am not going to give my client that real defense by just saying this shirt wasn't tested for DNA. And I think that the answer to that is you would have the shirt tested.
Okay, thank you.
Thank you.
Attorney Spate.
Good morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. You are all very close. This is strange. First of all, the defendant is, notwithstanding the attempts to minimize the role that the lack of forensic evidence, trace evidence, physical evidence played in the way this case was tried. And again, I think there is absolutely no reason to try to carve out the DNA testing on the shirt from all the other arguments about no tire tracks tested, no footprints examined, vegetative matter was not kept and examined, no fingerprints, no blood. The forensic evidence was crucial to this case, and that is because of something that I think my brother has not mentioned at all in his argument, and that is this is a case where we had a confession. Defendant moved to suppress the confession, unsuccessful. This will probably be an issue on direct appeal. The confession is in. The defendant puts on experts to say he was not in his right mind, it wasn't voluntary, he was in the hospital, he was on painkillers, he was weak, he had lost a lot of blood. That's fine. You can put on all the evidence you want that it's involuntary, but because the confession's before the jury, notwithstanding obviously the humane practice instruction that he would have gotten, you also have to show that it's false. And
I don't get that argument because at least I think in Commonwealth versus Wade, with respect to DNA testing, or forensic testing, we don't say you look at the strength of the case of the Commonwealth. That cuts against your argument because, and I take the lack of trace evidence is your argument, but whether or not he confessed or whether or not there was a bloody fingerprint or whether or not there's a videotape of him doing it, the question is what a reasonable attorney had tested the shirt. I don't get what you're going with the confession in the wake of Wade and the other cases that say we don't look at the strength of the Commonwealth's case. Because we don't say you don't get DNA tested if you have a strong case.
no, and no one said, that's not my argument.
All right, so where are you going with this?
When we started out, the first two cases that this court decided construing this statute, Wade and Donald, both had sort of procedural peculiarities that I think have kind of resonated through the case law ever since. In Donald, we had a defendant who filed monthly motions.
Tons of evidence against the defendant.
Tons of evidence, overwhelming, and what we call a frequent filer. And when this motion came across a judge's desk, not appreciating fully that 278A really meant to shift the landscape on this, she got out her rubber stamp and said, evidence was overwhelming, motion is denied. And this court quite rightly said that you cannot deny a 278A motion based solely on the strength of the Commonwealth's evidence. That's precisely what it's meant not to do, was to give a defendant a chance, even where the evidence was overwhelming, even where it's so overwhelming that he pled guilty. I do, and Wade had some, in Wade, the defendant had moved for a new trial before 278A, arguing that his trial counsel was ineffective for not having sought the DNA testing that he was now seeking
All
under
right,
the
so
new
we've
statute.
established the strength of the Commonwealth's case is not the test for 278A.
It's not the test. But I also want to remind the court that both the first Wade case and the first Donald case were Section 3 cases. They were not decided
Yeah, but we don't shift.
under Section 7.
We don't shift it. Section 3 is whether you get a hearing. We're past that, and the judge
And
appropriately said
we've
there's a
had a hearing,
But-
and
But where does the strength of the case come in statutorily in Section 7?
I'm not arguing the strength of the case, I'm arguing the character of the evidence, what it was, how it came in, how it fit together. Honestly, I don't know how you can make an assessment of whether a reasonably effective attorney would seek testing in a given case without an understanding of what the other
I'm
evidence
still
is.
baffled about your discussion of the confession, because if he's claiming it's a false confession, wouldn't he want the DNA evidence to exculpate, to say, yeah, it really was?
Only if it exculpates him.
Right, which is,
And it would have some force if you did that. But if there's a match to the defendant, then not only have you lost your argument that there's no forensic evidence, but suddenly you've lost suddenly the confession is corroborated.
right,
And so that's something more than just there's no evidence to link, there's no physical evidence to link the defendant to the crime. It's suddenly, oh, that confession looks a little different once we have some DNA to corroborate it. And I also want to point out that, if you're swabbing the chest and the armpits of the shirt, the innocent explanation is a lot harder to make out.
Let's take the appellant argument, though, which is that they're facing an overwhelmingly strong case. That's their argument. Their argument is, my goodness, look at what he's searching for on the internet. Look at the email. My goodness, the GPS matches where the bodies dropped off and the timing matches. And I'm not going to go on everything else because I'm going to run out of fingers. There's very strong evidence. Why not throw the Hail Mary?
Because the Hail Mary eviscerates the entire defense.
Yeah, I understand, but I think that they
Because-
had a good response to that. The entire defense, what they're saying was, in the face of all this, running out of fingers, talking about the defense, that they needed a Hail Mary. Not every lawyer, but a reasonable lawyer wouldn't go out at closing argument and just rely on the forensics as a trial strategy. The craft of advocacy is going to need something else to get to not guilty here.
I think a reasonable lawyer could very well do that, and I think it's more likely than not, and that's the standard on Section 7, I think it's more likely than not that a reasonable attorney would not roll the dice on that, because if it does come back to the defendant, it's very, very bad indeed for him.
But how
And
much
if you
worse
get
is
the-
it?
That's
I
the
guess that's the
question.
point of
Well-
Justice Lowy's question, is that, it's looking pretty bad.
I think it's
And
pretty irri-
maybe if I roll the dice and it shows up that there's,
We get a full
somebody
profile
else's.
on the armpits of the shirt, unless he's going to claim that they were wrestling in the parking lot or that they were having a tango lesson. I don't know how you explain that. Like the absolute best case scenario for the defendant is a couple of flakes of epithelial DNA that don't match him, which is of extremely limited probative value, given that it's the outside of the shirt and DNA can be picked up from anywhere. And there's this, imaginary person who has a motive to kill rakes, but has not been suspected and not. If they're, maybe if we had a little more developed third-party culprit, an actual third-party culprit, instead of an imaginary one, the balance could shift a little bit. I mean, this is why I think we're not just talking about the strength of the evidence. We're talking about what was the evidence and what role would this play if the testing were done? And
How prevalent
I think the
was
court has to
Bowdoin?
consider that.
How prevalent was Bowdoin?
Bowdoin, I'm trying to remember if there was a Bowdoin instruction requested or given. I don't think that's dispositive. All of the investigative witnesses virtually were cross-examined with the fact that they didn't find a fingerprint, they didn't examine the tire tracks to compare them to a car that at that point we didn't know what it was. We didn't examine the footprints. That shirt was never tested. They didn't find fingerprints in the car. They didn't find blood in the car. It was, I mean, if you count up the number of pages, maybe it's not as voluminous as some other bits of testimony, but it was a crucial part of the case. And it goes away if suddenly you have the defendant's DNA in the very spot where someone dragging his body into the woods would be. And suddenly that confession is a lot less challengeable than it was at trial. And I would submit, I don't think even, we don't have to prove that every competent attorney would seek the testing. By the same token, I don't think that the motion has to be allowed unless a court finds that no competent attorney would seek the testing. I think we're close to that in this case. And if there are no further questions, I'll rely on my brief and ask the court to affirm the denial. Thank you.